This is State of Ohio versus Kevin Taylor. It looks as if the state has waived its oral argument, and so you have 15 minutes to present your argument. We have read the briefs and we're prepared to hear your argument.
Thank you very much. May it please the court, my name is James Armstrong and I represent Kevin Taylor. I actually was in a rare circumstance. Usually I'm handling just the appeal here. I was also trial counsel, and since I was first assigned this case, I've been asking where's the evidence against my client since I was first assigned this case, to the point where I made a reference to the prosecutor during as we were getting up to the trial, because it took about a year from the time of the arrest to we ended up going to trial. We obviously waived the jury in our case. I reminded him of the old Wendy's commercial, "Where's the beef?" to say, where's the evidence in this case, since we weren't there on trial with regard to Alvin Banks, the homeowner, or Maurice Wynn, one of their witnesses, or any of the other 46 people that were arrested that night. I asked, what did specifically Kevin Taylor do to, I can understand actually the arrest because they were all at that party together.
I was going to ask, there's no dispute that he was there.
He was,
and not on the fringes looking in, but he was in the room or in the, where the activity was taking place.
I would distinguish the activity taking place.
Okay.
I would distinguish it, Your Honor, in this way, and this is the analogy I use in my brief. If I'm in Columbus at the Horseshoe for when there's an Ohio State game going on and I'm tailgating, that does not mean I'm there to attend the football game. That means I may be there to attend the party surrounding it. And it's a very important distinction in this case, because according to the state's case, and the defense, none of the defendants, they tried a number of defendants together, 3 total. The defense pretty much rested on the fact that the state didn't establish the elements that they needed to establish. But just focusing on the state's case, which I know with both the sufficiency and manifest what you must do, using the state's case, the state said it cost $75 to enter the garage where the dog pen was. My client had $40 on him, which means he's $35 short of even being able to attend if he wanted to. So with the state's very first, I think it was his first witness, Maurice Wynn, it's established that he didn't even have enough money to attend the event to begin with. Now, did he have enough money to be there at the party? Well, there doesn't appear to have been a cost. Eat the hot dogs, have the beer, and be there part of, with maybe a number of other people. There was also no connection with Kevin Taylor and any of the dogs that were there. I mean, this was a horrendous situation through dogfighting. I'm not even going to argue that point. I couldn't do it with a straight face, and I couldn't sleep if I tried. But the fact is that being at a party does not mean you were at the dogfight. There's no evidence that he paid to see a dogfight. There's no evidence he was even in the garage to see a dogfight. That's where the actual arena was. That's not really in dispute. That's where the pen was. The only entrance was through, as they called it, the man door. I mean, they have it's a garage door, but that was shut, and the only man door to go through. That's the record has the photographs and the evidence showing that. But to enter that door, according to the state's case, it cost $75.
Well, was there any other testimony as to the amount of money that your client had? In other words, from reading the briefs, it sounded as if the officers, what was a chaotic scene, but when the officers did process the defendants, that they took cash from them. And so did any of the officers testify that when they got to your client that he only had $35 or $45?
Yeah, it was 40, Your Honor.
$40.
And 35 comes with, that's how much more he would have needed to attend this. Yes, it was testified that not only did he have $40, but that's what they tried to claim, the forfeit, which in something I don't really understand, the trial judge said, well, that wasn't proven to be part of the dogfighting, the $40.
Well, so there was also evidence that in the chaos that surrounded the SWAT team coming in and all of that, that there were wads of to be able to pay to get in, to participate.
Judge Moore, your question answers so many problems in the case to begin with. First of all, if you want to say, could the judge have reasonably speculated that my client threw away $1,000 but kept 40? That doesn't make a lot of sense, because if you're tossing money, how do you keep $40 in your pocket?
But it
Now-
depends on how the money is,
But-
separated.
But with regard to that question, I think that may be a reasonable conclusion if somebody had no money on them. I mean, you're at a party, there's a dogfight, and you don't even have $1 on you. That's a little suspicious. When you only have 40, the idea that you tossed whatever else you had minus the 40, I mean, that's a real difficult thing to believe. Second, if my client in fact,
Excuse me, why? He has money, maybe he put some money into the pie, and he has the difference, $40 left, he hasn't yet had an opportunity to put in the pie.
Judge, where is any of the evidence indicating that happened?
No,
And I say that rhetorically.
It's just what kind of inference could be drawn from the total scene, the
Well,
evidence of the scene.
Your Honor, again, you have, the person, Maurice Wynn was found with $1,600 on him. And there's people that were, $400, $600, $2,000, all these different amounts of money. And then you're my client with $40. And then to sit there and try to extrapolate, well, the others had money, therefore he must have had money, and therefore he must have discarded it. I mean, you're basically saying A plus B equals F, and you're skipping the rest of the elements in between to get to that conclusion. And that's the reason from day one, I'm like, okay, where's your evidence that he paid for to attend this dogfighting thing when you're looking at numerous other people that have, some of them thousands of dollars on them, or a couple have $0 on them, which to me would have been far more suspicious than somebody that has, $40 on them. I mean, I don't know too many people that walk around with $1,600 in their pocket, and when you consider the reasons that the state gave for dogfighting, which is the entertainment value, and you bet on them, and those type of things, bless you, Your Honor. If you work on the assumption that, well, maybe he had paid for that, let's just, for sake of argument, the court, I think, realizes I disagree with the premise of the question, then that leaves him $35 to bet on an event, because according to what the police said, they rated it before any dogfighting actually took place.
That is if you assume that he didn't throw away a lot of money.
Again, Your Honor, how do we assume that based on what? Other than we found some money. We have to assume that he threw away all but $40. Well, if he's going to throw away money, why would he keep the 40? I mean, there's just a lack of logic to that, to come to a conclusion that somebody's guilty beyond a reasonable doubt, and the fact that you have to even speculate as to what happened with the rest of the money clearly indicates the trial court was losing its way and failed to judge Kevin Taylor's action. I'm not talking about the actions of others. I mean, Alvin Banks actually went federally. He came back, he took the fifth with regard, because apparently the state hadn't done that, with Maurice Wynn, who's sitting there with $1,600 in his pocket saying it cost $75. That's my biggest concern about this case, that there wasn't enough evidence to convict him, and two, what we did was like, well, there was enough people there guilty, so we can assume that he probably had this, and probably had this, and probably did that.
Sort of guilt by association.
It was completely guilt by association, Your Honor. And even if you look at the transcript, I mean, I think the transcript's almost 400 pages long. I mean, I think there's like 4 references, maybe 5 references to Kevin Taylor's name in 400 pages about all that took place. I mean, it's hard to even find his name anywhere.
Was there any testimony about where he was located? I mean, I understand it's chaotic, but there's also something in the briefs to say that when the police officers commanded that everyone stay put, they all ran. So I mean, I don't know about the situation where they're in the arena at some point, having paid their admission, and I mean, is there anything in the record about this particular defendant where he was located at the time of the arrival?
No, all the testimony was the collective.
Okay.
Everybody ran. Well, who's everybody? did anyone stay put? Well, you know, this was a very chaotic scene. There's no question with regard to that. And that's the reason you sit there and you look, okay, he was, and that's the reason I said there's no question he was at the party. That's the reason that you stress. You know, one sense, the state's showing all the photographs of the dog pen, all the pictures of the man door and those type of things. And then their own witness says it cost you $75 to get into the garage to see the dog fighting. Okay, so if that's where the dog fighting took place, and I think it's reasonable to assume that if they have evidence of somebody paying to get in, that's clear evidence. If you have a person such as my client who didn't even have enough money to enter that garage, and that's the issue, and the only way to get from point A to point F is assume, you know, D and E, then one, he wasn't given the presumption of innocence, and two, he wasn't, the state clearly didn't meet their burden of proof, because it's not, I don't think the trial court should be in a situation, and I certainly don't think this court should be in a situation of trying to guess at how the trial judge came to that conclusion. And unfortunately, the trial judge never gave us any clue of how he came to that conclusion. And this is anecdotal, but in 25 years of practice in law, I think that was the most shocked I've ever been with a decision, because I didn't see any connection other than getting arrested at the party to the dogfighting, because he didn't have, you look at the money, you look at the fact that he wasn't in contact with any dogs, any cars, anything. We had cars from out of state that were here. Well, clearly if somebody's coming from Illinois and they got a dog pit in their back seat, it's kind of tough to argue you weren't there for the dogfight.
I need to understand the whole layout better, but my question is, we know that he only had $35 on him when he was picked up, correct?
40.
Or 40. What we don't know is how much he arrived with and whether or not he paid. Is that correct?
I would, from the testimony and the transcript, yes.
Okay, so from that, a reasonable person could conclude, or your point is, from that, a reasonable person cannot conclude that he had the money with him and paid to participate.
Your Honor, I would agree with you. If you look at everything the state presented as to not only what took place, what it cost to get in there, but also the reason for the dogfighting, mainly to bet, and the fact that it was undisputed that they really hadn't gotten started with the dogfights, because fortunately the police actually got there to prevent the dogfighting. How do you really can't get to him being guilty of the dogfighting, because everything they indicated for the purposes, he didn't even have the money to do.
Would it make a difference in your analysis if when the police began the raid, he was already in the garage?
Absolutely.
Without regard to the amount of money that he had in his pocket?
I would say, you know, absolutely. Because if he shows up with, I don't know, if he had 40, what is that, $125 in his pocket, I don't want to do the math real quick, $115. You know, you can argue that, well, maybe he was going to bet big, but he wanted to see the spectacle. You know, at least he'd be in the garage. At least that gives you some sort of inference. Right now, we have nothing. And we don't even have a clue from the trial court as to how they came to that conclusion, because it was never provided. And I know the judge said, I think on the record, that he doesn't have to tell you why he found somebody guilty. But on the same token, my client still had the presumption of innocence. And when you're saying, when you have to speculate as to, well, did he have more money? Then all of a sudden, what's the sense of having a trial if you're allowed to speculate about things that was never presented?
This is going to display my ignorance about this subject. But is it possible that someone can go and watch a dog fight without putting money in and be innocent of the crime that has been alleged? In other words, being a spectator is not a violation of the statute.
I would say yes because, well, first of all, the trouble we have is we couldn't find anywhere where this has ever been actually interpreted before. According to what the trial judge said, you actually have to pay money just to do that.
Or give something of value.
Or something of value. So I'd have to say, being a spectator without paying anything of value, I think it's the paying of value that triggers the statute. I think you need both of that circumstance.
So, on this record, is there a record of paying money or anything of value?
For Kevin Taylor?
Yes.
Absolutely not. Not a shred. Not a shred of evidence. And furthermore, Your Honor, is that would be the reason why that there were actually no windows even in the garage for the dog pen. So you wouldn't be able to just go there and look through the window to see it. You would have had to actually physically go in there. Just as if you're at Ohio State Stadium, you can't see anything from the parking lot to watch any of the game. You may be able to have the hot dogs and enjoy some of the tailgating, but you're not actually watching the football game itself.
And you've reached the end of your time.
Thank you.